Good afternoon to your ladyship and my lords. My name is Michelle, the first respondent, petitioner, together with my colleagues. I will address you on the question of the remedies available and on the question of jurisdiction raised by the respondents. My lords, and it's important so that we understand what is in dispute and what is not in dispute. The respondents in their submissions, and by this I refer to the submissions by the first respondent, they ran to over 120 pages and are dated the 17th of September 2025. We have today received submissions on behalf of, I believe, the second respondent and the eighth. The speaker, no, actually the first respondent, that's the speaker of the National Assembly, and the eighth respondent, the deputy speaker of the National Assembly. In their joint submissions, this, in summary, is the case they intend to put forward and which will be the basis upon which they will be asking you not to grant the orders I am about to beseech you to grant. At paragraph 95, they begin by making concessions, which is always a good place to start. They concede that public participation is necessary for purposes of the impeachment proceedings that are before you. They concede that judicial oversight is within the powers of this court as regards the impeachment proceedings. They then muddle up their submission somewhat at paragraph 107 by stating that impeachment is a purely political process rather than a judicial one. At paragraph 107, they seek to limit the purview of this court's mandate by stating that the court review of the decisions or the process does not include interrogating substantive merits of the impeachment charges. They, however, concede at paragraph 109 that this court has jurisdiction and power to examine whether the constitutional and statutory procedure for the impeachment was followed lawfully. That's paragraph 109. They concede as well at paragraph 109 that this court can examine the question as to whether the petitioner's rights were violated. I believe they are citing a decision of the Court of Appeal in making that concession. They then repeat at the same paragraph that the court cannot reevaluate or substitute or interrogate the substantive merits of Parliament's decision. And I'll be demonstrating to this honorable court why that is not the correct position. Having conceded that public participation is necessary, as they have at paragraph 95, they then seek to somehow circumscribe their concession at paragraphs 292 and 294 by saying that Senate did not require to conduct public participation. It's the boldest statement negating public participation I have ever had by a state organ. At paragraph 183, they make the point that fairness is required as a part of the process and that it requires careful consideration. And as regards what my learned senior counsel, Mr. Paul Muite, alluded to here earlier this morning regarding the events of the night when the IBC was consulted, leading to the nomination of the current Deputy President. They make the point at paragraph 380 that the National Assembly was not conducting a normal vetting process. It was a vote. In fact, they make the point that it was an election. Those are the words they use. And this is now to be found in the submissions of the first and eighth respondent at paragraph 68 to paragraph 70, that the President, in consulting IBC on that night, was not doing so as a matter of constitutional requirement, but was doing so as a matter of abundant caution. He was being careful. He didn't require to do so. Those are the points they make. Now, this court is imbued and clothed with authority, first and foremost under Article 22 of the Constitution of Kenya, and I don't need to read all the remedies that are set out therein. But among those that are set out there and relevant to our client's case, one is compensation, E, and F, an order for judicial review. And then at Article 165, subarticle 6, the High Court has supervisory jurisdiction where it is examining a decision arising from a quasi-judicial proceeding. And this is important for reasons that I will make known shortly. Now, I call this court's attention to Section 11 of the Fair Administrative Action Act, and it's an important act for many reasons, because whereas Parliament has made very lengthy submissions on many things, Parliament constitutionally talks through the laws it passes. This is a law Parliament passes directing what is to be fair in a proceeding such as this. And I begin first by making the point, and the respondents agree with me on this, and I'll be demonstrating where the submissions. They say that the Senate proceedings were quasi-judicial. That is the word they use themselves. And perhaps I think I should actually identify the exact paragraph where they say, I believe this is paragraph 292 of their submissions, where they say that the Senate was exercising a quasi-judicial authority. Yes, indeed, at paragraph 292 of the submissions by the National Assembly itself. And this is what they say. We submit that the Senate's function under Article 145 is not a legislative function, but a quasi-judicial and adjudicative role. The words quasi-judicial are the same words appearing, as I've stated, at Article 165, subarticle 6. But perhaps more importantly, under Section 2 of the Fair Administrative Action Act, and the Act begins by stating, this is the rationale for the statute by Parliament itself, this is an act of Parliament to give effect to Article 47 of the Constitution of Kenya. And this is what they say. Administrative action is defined as the powers, functions, and duties exercised by authorities or quasi-judicial tribunals. And so, by concession, by admission of the Senate, the decision, the process they undertook was quasi-judicial and therefore amenable to the Fair Administrative Action Act. And this is important because at Section 5, the statute says that in any case where the proposed administrative action is likely to materially and adversely affect the legal rights or interests of a group of persons or the general public, it then says what must be done. Amongst the first things that must be done is that there must be the issue of a public notice of the proposed administrative action inviting public views in that regard, public participation. Senate was required by the statute, by Section 5, to conduct public participation. They have admitted they did not do so. Number two, they are to consider all views submitted in relation to the matter before taking the administrative action. They were to consider everything said to them during public participation. They elected not to do so. They are to consider all the relevant and material facts, and D, where they proceed to take the action, they are to give reasons for the decision of the administrative action as taken. Again, they did not do that. That was not done. Now, and my good and learned senior here, Mr. Swanya, will be coming to give a few more details on the question of public participation, and I'll touch on a few others. But then, at section, I believe, section 7, subsection 2, this court is provided with a marking scheme. It is to apply when considering whether administrative action such as this met the test of the Constitution and of the law. I have been shocked in my own examination of the question to find that the National Assembly and Senate reached a mark. The examination mark was equivalent to my Form 2 physics examination, 0 out of 100. That is the figure they found. A self-supporting 0, and I'll proceed to demonstrate the points. Section 11, Section 7, subsection 2, I've read out to the court, states that the person who made the decision, and this is one of the criteria that the court is to look at, whether that person was not authorized to do so by the empowering provision. Now, you've been told, and as I've pointed out here, the respondents make the point that the president was only acting as a matter of abundant caution. Now, it is not in dispute, I think it is common ground between us, that the IEBC did not have commissioners or a chairperson. In 2025, the Supreme Court of Kenya handed down a decision. It is part of our list of authorities. It's called IEBC versus the Attorney General, 2025. At paragraph 62, this is what they say. It is uncontested and indeed a matter of public record that at the time of filing of the present reference, IEBC was not fully constituted following the exit of its previous commissioners. There was at the time no indication as to when new commissioners would be appointed. As such, the commission remained for all practical and constitutional purposes incapable of discharging functions that by law require the participation, deliberation, or approval of a properly constituted commission in accordance with Article 251 and 252 of the Constitution. That is a binding decision on this court, and if there were any doubt as to whether the president was actually required by law to do this, or whether he was actually acting as a matter of abundant caution, as it states, I call the court's attention to Article 88 of the Constitution of Kenya, the provisions of the IEBC, the Elections Act, as regards what a nomination is, and with particular attention to the definition of the word nomination. Amongst the other things, the Speaker of the National Assembly had no authority to approve a motion that was based on a law that was declared unconstitutional, because it cannot be a high offense. It cannot be a violation of anything. You cannot violate that which does not exist. That is amenable to review by this court. One of the other tests is whether the decision was made in excess of jurisdiction or power conferred under any written law. Now, the Senate, as senior counsel here said, worked with ungodly speed in impeaching the first petitioner before you here this afternoon. But apart from that, as regards the appointment of a replacement candidate, the Constitution has 74 days within which this decision could be made. 74. It was made at night, within less than 24 hours. So this kind of, there was no power to act with such ungodly haste when you are allowed 74 days to take your decision. Now, the speakers of both the National Assembly and the Senate, as my good friend Elisha Ongoya said here earlier, were beneficiaries and signatories of shareholder agreements which have been placed before you, which formed the basis of grounds 1, 5, and 6 of the impeachment motion. One of the fundamental rules of natural justice is that you cannot sit in judgment of your own cause. They were sitting in judgment of a cause in which they were not only beneficiaries. In the case of the National Assembly Speaker, who I have tremendous regard for, he was a signatory. As senior counsel here said this morning, the replacement, Honorable Kithure Kindiki, professor, a man I have a lot of regard for as well, was the witness of those agreements. The President of the Republic of Kenya signed and bound himself to those documents. And it's important to understand that these documents were not being done as a matter of abundant caution or as a matter of political games. The Political Parties Act requires a coalition agreement to be the foundational document for a coalition. So the Kenya Kwanza government is founded on the basis of these shareholder agreements. And when the Deputy President, elected on the basis of those shareholder agreements, insists that those agreements must be complied with, he's called a tribalist and he's impeached. As Jesus would say, first take the log from your own eye. Impeach yourself as the government first for basing your government on a tribal agreement. Then get rid of your Deputy President. Now, the National Assembly was scheduled to vote for the nominee to replace the petitioner before the Senate had voted. Again, senior counsel spoke to that, and I won't say much more. But what I will say is that last year, the High Court handed a decision, and I believe this was a 3 or 4 or 5 bench decision, and it's part of our list of authorities, in a case called Njiro and 11 others versus Kenya Kwanza Coalition and 18 others. It's part of our bundle of authorities. And this is what they said at paragraph 489 of their decision. We hold and find that the simultaneous holding of the position of Speaker with that of the leader of a political party and the leadership positions in the ruling political coalition, as is the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya and a holder of key position in Kenya Kwanza Coalition, reasonably evokes appearance of bias. And I say this because bias is one of the tests Section 7 of the Fair Administrative Action requires you to look at. And I continue. And undermines his neutrality role as the Speaker of the National Assembly and the independence of Parliament as the symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law, principle, and Article 10(2)(a) of the Constitution. And this is what they say. This dual role is unlawful and unconstitutional. I am aware that the National Assembly sought to stay that decision, and that attempt to stay was rejected by the Court of Appeal. There's a decision available on the Kenya Law website. And so, where you have a court decision stating that the referee, the man conducting this impeachment, the man issuing the decision, the man reviewing the motion is biased, is a violation of the rules of natural justice. One of the decisions we have submitted before you, and my good friend Mr. Dudley is a bit more eloquent on pulling them out of his head quickly. The court has said that any decision emanating from a decision maker in violation of the rules of natural justice is not a decision. Now, when you look at Articles 95 and 96 of the Constitution, the process of impeachment begins or is initiated in the National Assembly. Article 96 then uses some very interesting words and states that the role of the Senate is to consider and deliberate, not on the motion, on the resolution. Those are the exact words of Article 96. And so a resolution emanating from a process shepherded, led by an individual who has been found to be biased is no decision at all. Now, the person who, this is one of the other criteria that the court is to look at, whether the person who made the decision denied the person to whom the administrative action or decision relates a reasonable opportunity to state the person's case. It is important, while looking at this particular question, to examine, according to the first petitioner, where his problems began. I call the court's attention to paragraph 65 of his further amended petition, in which he states that his problems emanated from exercise of his freedom of expression, Article 33, following demonstrations that led to the unprecedented in Kenya's history occupation of parliament by the citizens of Kenya. That is paragraph 65 of his petition. And the reason citizens of Kenya, who called themselves Gen Z, occupied parliament was that they said they were not being heard. Their participation was not meaningful, and the only solution they could find was to occupy the August House. That is the beginning of this problem. And so, when Parliament embarks on a public participation process, it is incumbent on it to first advise itself of this history, that this man has been impeached because he made a statement in support of people who occupied Parliament. And so what do? And they concede public participation is necessary. My good friend Mr. Swanya will come and address us a bit more on this, but they give Kenyans 2 days to give public participation. When this court retires to look at the report, because what they did, they then collated, they issued forms. These forms had no serial number. These forms had no way of being verified whether these are Kenyans filling them or not. These were just forms that were distributed all over the place. But they then form a report. And when you look at the executive summary of this report, they say that they received 200,000 responses from the whole country. I did a bit of mathematics. 200,000 people as a function of the 14 million people who voted for the first petitioner and his president comes to 0.014 of the voters. Those are the people who participated. Now, I did a bit of maths in A-level. When you round off 4, it becomes 0. When you round off 1, it becomes 0. So there was 0 public participation, mathematically. It's that simple. 200,000 people out of 14 million is 0. A bit like the result I'm about to give you here on account of their compliance with the law. So you have 0%, and these are figures they themselves have given. In the executive summary, they list 10 problems they had with this public participation. They say there was very poor turnout. In one case, I think it was somewhere in KU, 168% people turned out to give their opinion. 68% spirits showed up to give their views in one particular case. And an order was actually issued against this process on that account. They then, in this form, list the allegations against the Deputy President. This is the National Assembly. But then don't give the people what the Deputy President's responses are. And this is not an idle issue I'm raising here, because, as I stated, and under the Fair Administrative Action Act, Section 5, they must give the public the opportunity to consider all relevant material. All relevant material cannot include the plaintiff, but not the defense. That was a fundamental dereliction under Article 50 and under the Fair Administrative Action Act. They then say, based on these forms of theirs, that from the entire country, all 50 million of us, they received 8 written memorandum. 8. There are 41 petitioners before you this morning. There are more petitioners here than the number of memorandum they received. 8 of them. 1 per province. Kenya used to have 8 provinces. So again, on average, we got 1 memorandum per province of Kenya. That is what we call insufficient, inadequate, unreasonable, unlawful, unconstitutional. One of the other criteria the court is to look into is, and I think I should point out at this point here again, reasonable opportunity of being heard, which we'll find is one of the criteria. I won't say much about it. Senior counsel has dwelt at length about it. The Senate is informed that the Deputy President is unwell. They even ask senior counsel, it's part of the Hansard, to convey quick recovery to him. It's actually there. They tell him, go tell him to recover quickly. Pray for him. They then say, but while you're praying for him, we will proceed here to hang him as you are praying for him. This is what they did. Now, how are we ever going to face Kenyans? By telling them this is what a fair hearing in Kenya looks like. As we are praying for you, we are slaughtering you here. We are praying for you with one hand, slaughtering you with the left. How are we ever going to face Kenyans and tell them that is the kind of justice we practice in this country? How are we ever going to tell them that is what Article 50 as regards a fair hearing means? One of the other criteria is that did the decision maker omit or fail to take into account a critical issue, or did they omit a condition prescribing the power they are to follow? My good friend, Mr. Dudley here again, has talked about the Senate proceeding to vote without appointing a special committee. The court has enough material on that. But the courts, and I say so with tremendous respect, will also have time to look at what the Supreme Court said as regards this committee. It said, we recommend the committee route as opposed to this lynching. The words lynching came from them there. Mob justice, goon justice. They said, do a committee. You'll have time to look at that. I've said they did not conduct a constitutionally compliant public participation exercise. And as I said, it's required not only by the law, Articles 10, Article 118, Section 5 of the Fair Administrative Action Act. But again, my lords and your ladyship will have time to look at the BAT case, again the Supreme Court case, that gave the 8 or 10 criteria that are to be looked into in examining whether public participation was properly carried out or not. Among the other criteria that the court is to look into, again from the same Section 7, is whether the administrator failed to take into account relevant considerations and took its action or made the decision in bad faith. Did they consider everything they ought to have? I have a long list of things here, and I won't spend any narration on them. One, they did not take into account the Wambora Court of Appeal principles on the threshold test for impeachment. That is where the threshold test was made. They did not take into account the Sonko Supreme Court case principles on the need for a special committee. They did not take into account the BAT Supreme Court case principles on public participation. They did not take into account the Onyango Olo Court of Appeal case principles on fair hearing, and in particular, what is adequate time given the circumstances. At this point, I should point out, when the Supreme Court is determining whether to annul or uphold the president's election, it normally has 14 days. It normally gives a summary judgment and then reserves reasons for many months later, again because there just isn't sufficient time. And so, why the National Assembly and the Supreme Court in 2022 in its judgment actually said we ought to amend the Constitution to provide for more time, you know? Now, why the National Assembly, which has been asked this, and in fact, in 2022, the Supreme Court said this judgment should be served on the National Assembly for them to remedy this question. Both the National Assembly and Senate did not take into account Article 50 on the fair hearing requirements. They did not take into account Article 94(4) of the Constitution, which requires them to protect the Constitution and promote the democratic governance of the Republic. I've already cited Section 5 of the Fair Administrative Action Act and other provisions of that act. The resolution by the National Assembly adopting these allegations, which concerned spurious frivolous, vexatious matters about the first petitioner's family matters, which had been dealt with by a succession court, which was the subject of rulings by the family division, were thrown in just for the heck of it to harass the man, and were designed to violate his rights under Article 31C, which protects every citizen from having information relating to their family or private affairs unnecessarily required or revealed. And in the fullness of time, you will find the Senate actually refused to uphold this ground. The ground had been put there purely to embarrass him, to embarrass his family, to embarrass his supporters, to harass the man. That cannot be a proper motive. That is an improper motive by this party. They failed to consider that the DP, and again, this is the Alai case. My good friend, Mr. Dudley, referred it to the Alai case. In the Alai case, the court said, and there'll be another case I'll be reading out here for you shortly, called Ferdinand Waitito, that you are free to express your opinion. And so, as I said, the first petitioner begins at paragraph 65 by saying all his problems are because he spoke about the manner in which his government had mismanaged the demonstrations by these young people called the Gen Z. Now, we are about to compensate them for shooting and killing them. Now, this will be the first judicial decision that will provide guidance on the interplay. This is an important one because it keeps being repeated, and my learned friends here have paragraphs upon it in their submissions. The interplay between hate speech and incitement, which are stated to be offenses under sections 13 and 62 of the National Cohesion Act, vis-a-vis the freedom of expression under Article 33, the political rights at Article 38(3)(c), and the rights of all citizens, including political leaders, to advocate for and protect, express ethnic rights identified in the Constitution. I say ethnic rights with that reason. The first petitioner is accused of stirring hatred, potentially inciting people, because he used the word Mount Kenya. The little geography I learned, Mount Kenya is a rock in the middle of Kenya. It is not a tribe. It's a stone in the middle of Kenya from which we got our name as a republic. Even if you are to count the counties that surround it, they constitute people from every corner of Kenya. They don't have one tribe. He didn't use a tribe. He said Mount Kenya. Mount Kenya is a rock. He can talk about a rock. Number two, even if he was talking about ethnicity, Articles 21, 27, 63, 90, 91, 100, 130, 232, 241, 246, 250, and a myriad of statutory provisions that I could bring here, all talk about ethnicity as a constitutional principle worth defending, worth being held to account for, worth advocating. All of those mention the word. In fact, I found that the word ethnicity appears more times than the word economy. Economy appears twice. Ethnicity 11 times. So, how can you be accused of speaking of an issue the Constitution spent 11 articles talking about? But even more important, in 2016, the late Justice Louis Onguto had occasion to consider a case I have circulated to my colleagues this morning after I got their submissions, and I think I have given the court, my good friend Mr. Njomo, the court's copies. But this is the case of Ferdinand Dongo Waitito, also known as Babayao, and 4 others, versus the Attorney General. It's reported. This is what Judge such as those about to be made by the respondents, and this is what it says. The Constitution allows every person to picket, demonstrate, assemble, and present petitions. Picketing and demonstrations themselves invite the right to express opinion. The opinions may be controversial. The opinions may appear contrary to the law. Appear contrary to the law. This is Judge Oyongo saying this. The opinions may not find favor with others. Yet, the Constitution anticipates and expects that such unpopular opinions, howsoever expressed, be respected. Now, not all of us can speak as good English as my good friend Dudley. or my good friend Professor Ojiambo here. But you're free to express yourself as you will. If you read a document that talked about shareholders, that is what you say when you go to the public. Why would you be vilified and impeached from ever holding public office for reading a document that founded a government? On what basis? He then says, even if they invite disagreements and counter demonstrations, this is the first time, I think it's good, Kenyans would know, counter demonstrations are allowed. Not just demonstrations, even counter. The Constitution thus far declines to stifle even the most unpopular view unless it is intended to incite persons to violence, propagate hate speech, is propaganda for war, or advocates hatred through ethnic incitement. When you retire to look at the provisions of the National Cohesion Act, sections 13 and 62, that are the basis of these frivolous grounds, they say the critical function is what my professor, Gideon Muigai of criminal law, used to tell us was called the mens rea, the intention. Did you have the intention to cause hatred and incitement? You cannot have had the intention when the document you are reading is the basis for the government that was formed. You cannot incite people with the government. You reward them with a thing nowadays called power and economic empowerment. You do not incite them. You can't cause hatred by talking about a government that was elected by people on the basis of a document. And so the DP's public references as regards these shareholders cannot be tantamount to hate speech. They cannot. This is public speaking, as I've just stated. And I should state here, the case of Ferdinand Ndung'u Waitito and the four others, among the four others are the current leader of majority in the National Assembly. So he knows this. When they were considering these grounds, he was aware of this decision because he was one of the petitioners. And they were told, no, you can't stop people from talking. Now, but then, they then went to the Supreme Court, the Court of Appeal, sorry. They tried to overturn this decision, and the Court of Appeal rejected that attempt. So this decision, I'm reading Ferdinand Waitito, has been upheld as well by the Court of Appeal. There are many instances where one would be said to have caused the hate speech or incited people or have said things that were unpopular. The first petitioner is accused of having spoken against the National Intelligence Service. When you retire to review the material before you, this is the Senate Hansard, and this is ground number 9, which we'll find at page 64. There is an interesting exchange where my good friend Ekomas Mutuse is being interviewed, is being cross-examined on the question of the NIS. And he's directed to a case where the current president, who, while deputy president, also very harshly criticized the NIS. So criticizing the NIS has not started now. In fact, the current first petitioner, who was the deputy president, should be accused of being a good student of his boss, the former deputy president, who's currently the president, because he too also criticized the NIS. So, and the NIS, as with any other state organ, can and should be criticized. No one is beyond criticism so long as it is well-founded, as turned out in this case. It is made politely. It is stated in good English, relatively good English. Our client spoke some fairly good English. He's a literature graduate. He said nice things. He said them nicely. Now, they offended the heart. But you know, no one is beyond criticism. One of the other things, I think, and we've stated this in our petition and submission, again, on the question of bias, the National Assembly Deputy Speaker, the 8th respondent, is on record as saying her instructions to execute the impeachment came from a building in Milimani called State House. And one of the things the court is invited to look at is whether the person exercising this decision acted on the direction of a person or a body not authorized or empowered to give such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say any more about that. But is the decision unreasonable? The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way. The evidence was not given to the public. They were just told he has violated Article this, Section this, and Section that. Most lawyers could not tell you, most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the votes in 2022, is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the Deputy President, but the nation at large. Now, the case I cited earlier, which is the 2025 IEBC versus AG case, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the principle of legitimacy. The principle of legitimacy has three pillars. Pillar number one, people must have voices and their voices must count. That's the first pillar of the principle of legitimacy. The second one is that public affairs and the law must be conducted with fairness and justice. That too was violated. And thirdly, that laws and rules must be consistent and applied evenly and predictably. I repeat, the current Deputy President is the witness of these shareholder agreements that led to the impeachment of the Deputy President seated here. The President, the Speaker of the National Assembly, the Speaker of the Senate, all are members of parties that signed and are beneficiaries of this agreement. How can we say the law is being applied equally, fairly, and evenly, even in the limited space of the political players, when one group is treated one way and one individual is treated another way? I want to rest this area of my submissions, and perhaps maybe you should allow me to just read for you, as I found my notes on the provisions of the Elections Act and the IEBC Act that deal with the question of nominating a Deputy President. These are Articles 82(1)(b), Article 88(4), the definition of the word nomination at Section 2 of the Elections Act, Section 22 of the Elections Act, and Section 4D of the IEBC Act. I want to close with the following paragraph taken from the decision of the IEBC versus Attorney General 2025 case. This was a case concerning the delimitation of boundaries, and the Supreme Court of Kenya said as follows. And this is the penultimate paragraph of their judgment. However, before we conclude, we must address a matter that has troubled us. And it is my very, very tremendously humble and respectful request to this court to also be equally troubled by the things that the National Assembly and the Senate did in this matter. The history of Kenya's electoral process, from the findings of the Kriegler Commission after the 2007-2008 post-election crisis, to the litigation around elections culminating in the 2022 presidential election, reveals a consistent theme, one of a deep-seated trust deficit. I beseech this court, do not countenance any further trust deficit based on the things the National Assembly and the Senate did. Trust deficit between Kenyans, the IEBC, and the electoral process. This deficit did not occur by accident. It occurred because of actions like the ones by the National Assembly and the Senate. Rather, it is the product of decades of politicization of the electoral process, relentless attacks on the Commission's independence, and a failure to implement electoral reforms in a good time and in good faith. Leaders exercising delegated authority, such as the National Assembly and the Senate, on behalf of the people under the Constitution, rather than fueling this mistrust for short-term political gain. It appeared last year, 2024, when the impeachment was going on. It seemed that there was a deadline by 20th October. And when I slept, I woke up with a eureka moment. The idea was to have a new deputy president at the holiday. You know, it gripped me. I hadn't seen it before, you know. And so undermining the very institutions they are duty-bound to protect should channel their power and influence toward addressing structural weaknesses, enhancing accountability, and reinforcing public confidence in the impartiality and competence of the IEBC. In this case, I say of decisions by the two bodies before you. Ultimately, the legitimacy, which is why I spent some time talking about the doctrine of legitimacy. And this is what they say. Ultimately, the legitimacy of Kenya's democratic order depends not only on credible institutions, but equally on the fidelity of political actors to the spirit of the Constitution and the sovereignty of the people, which was in question during this impeachment. Unless your ladyship and my lords have any questions for me, I want to thank you for the privilege of your time and attention. I'll rest at that point. I hand over to my senior, Mr. Swanya.
Thank you. I would like to make this comment that repeated issues are coming up in your submissions, and I want us to believe that we have heard most of those issues. If you find that you are bound to repeat what has been said, we want to assure you that it is not necessary.
Thank you. My name is Swanya. I'll address the court on notices. But before I do so, let me cite the Supreme Court, a case on PAT, which says public participation is a constitutional requirement under Article 10 and 118 of the 2010 Constitution. The Supreme Court, in a PAT case, held that public participation and consultation is a living principle that went into the constitutional tenet of the sovereignty of the people. Under Article 10, Sub-Article 1 and 2, as a constitutional principle, public participation binds and it is applied to all aspects of governance. Your Honor, and Lady, I want just to get down to some specifics on public participation. It is designed to ensure accountability, requiring public engagement, rather than just parliamentary approval. In the context of impeachment, it is a remedy of the last resort. This, I think, was mentioned by Senior Counsel Paul Mite. Therefore, the public participation exercise must meet the following standards, and this is what I wanted to get down to the specifics. One, must be purposeful and meaningful. Must be real and not illusory formality. It is not cosmetically done for Public Relations Act. Should not be undertaken as a matter of just to fulfill a constitutional requirement. The public participation exercise outcome must have quantitative and qualitative components. It is accompanied by reasonable notices and reasonable opportunity. Further, Your Honor, the court tried to highlight what is the components of meaningful and purposeful public participation. It must have clarity of the subject matter of the public, for the public to understand. The structure and process, that's the media of communication, of the participation, participation that are clear and simple to understand and follow. This particularly is the instruments that are used to collect data or to be given to the participants on public participation. They got to be simple, clear, and easy to follow. There must be opportunity of balanced influences from the public in general and commitment to the process. It must be inclusive of effective representation, integrity and transparency of the process, and capacity to engage on the public, including that the public had to be first be sensitized on the subject matter. These are the details that our guidelines the Supreme Court gave on the PAT case. So now let me just get straight to the notices. Before I get to the details of it, let me define what a notice is and a reasonable notice. A notice is a formal information to parties attached or necessary to a judicial process, informing them about the issues they need to know and given an opportunity to respond to them. The courts always will rely on the parties to properly serve notices to the affected parties. A proper notice is regarded to be proper and adequate when it has the following elements. Number one, it must be in writing and indicate the date issued. It must be clear and precise, or state the clear, precise object of the notice. Provide specific venue and duration if necessary. Provide adequate timelines and periods as may be stated in a statute or an agreement. It must refer to a statutory or an agreement or resolutions, and of course must be served. In the case of Battle versus Globe and Mails Limited, 1960, this a Canadian case, the Supreme Court, Ontario, clarified what is agreed, clarified on the reasonable notice, that where there is no agreed timeline in a notice, a reasonable notice kicks in. It is a common law concept that refers to fair amount of time that must be provided for the parties to respond to a matter that concerns them before a decision is arrived. The Lord, I brought this up because we do not have a codified law that guides the impeachment process, which has guidelines on the notices and durations or steps to be taken for an impeachment. And what we have only is what the Supreme Court, in the case of PAT, has given as guidelines. And so one of it is reasonable notice is necessary. And that's why I've referred this case where there's no notice, then automatically a reasonable notice kicks in and it talks about the timelines. Now let me state also in the case of Robert and Gakuru versus Governor Kiambu County, the court has been clear that arid or poorly publicized processes amount to illusory participation, being a formality incapable of influencing the decision. Therefore, reasonable notice to the 290 constituencies must be understood as notice that is sufficiently served early, widely disseminated, and accompanied by accessible information for realistically enable the citizens to engage. Anything less, particularly involving inordinately compressed timeline, undermines the constitution standard by denying the public a genuine opportunity to study the issues and be able to formulate a position and present meaningful representation capable of shaping the final decision as in the present case. Your Honors, I now submit on the National Assembly's failure to meet the standard of reasonableness and meaningful engagement. The National Assembly, in their own report, reveals a process that prioritized speed over substance, failing the reasonableness tests as follows. The notice ran for only 2 days. That is on 2nd and 3rd October 2024 for the public participation exercise, which was to be held on 4th of October 2024 at a purported initially a designated single venue at the county level. Additionally, the National Assembly report on 3rd and 4th October 2024 stated that they had 40,000 copies of the notice of the special motion were circulated as newspaper pullouts. This begs the question whether the 40,000 copies were adequate for meaningful national public participation and whether the 2 days were adequate for circulation of the same nationwide. My Lords, we submit that the timeline were fatal to the meaningful engagement because the entire national exercise was condensed into a 4-day window inclusive of the 2 days notice advertisements. This time frame is grossly insufficient for the public to digest a 100-page motion containing 11 complex grounds, legal grounds, including allegations of corruption and gross economic crimes. Your Honor, it's important to note that the first notice had a single venue per county. Your Honor, you can imagine an headquarter of a county, assuming that's where the exercise was taking place. The people who are at the ends of the county how would they access to reach the venue and participate in the public participation exercise? This is contrary to actually what the Court of Appeal, the Supreme Court, rather, guidelines had provided for. The other point, Your Honor, according to the report, the nationwide public participation exercise at the constituency level gave 1 day notice on 4th of October 2024, the same date as the court ruling. Let me clarify here that the participation exercise was supposed to be on 4th of October 2024 for 1 day. But the ruling of Justice Moho, your brother, extended the participation for another 1 more day. Now that advertisement or publication also came in the same day when these exercises were supposed to finish. Now, what would happen that to the common mwananchi? Of course, confusion. Similarly, the orders which were given said that now the exercise should move from the county to the constituencies. The Honor, what we noticed here is that in the constituencies, just talked about constituencies, never gave a specific place, address, where this exercise is supposed to take place. It's our submission that such an important exercise to remove the Deputy President from office, who was elected by the majority of Kenyan in each gazetted polling station in the country, required a similar methodology and the participation to remove him from office. And certainly, the purported NGCDF officers advertised without prescribed venue address did not meet Justice Mwongo's court order to provide venues close to the people. In any case, the only venue close to the people is polling stations. The Honor here, as I said earlier, even with the orders needed to have the exercise done at the constituency level. And the assumption here is that each constituency has these offices. But then what's the distance between where those offices are? The one who's prescribed for somebody who's at the end of the corner of that constituency. By using highly legalistic language in the notices of public participation and in the circulated public view template, the assembly created a barrier to entry for the average mwananchi, reducing a constitutional right to a binary of support or oppose vote. The report indicates that primary information was posted on the national television broadcast, KBC, print media, the parliamentary website, and social media, which was technologically biased and excluded vulnerable groups. In the BPI case, the court stated that relying heavily on technology ignores the reality that only small fraction of Kenyan as reliable internet access, and that technology has not been dispersed equitably to all Kenyans. Similarly, despite the Persons with Disability Act of 2025 requiring free sign language and braille in public forums, the Gachagua impeachment exercise failed to provide even the most basic reasonable accommodation for these 5% of the population with special needs regarding the exercise, which was unconstitutional as per Article 54. The report does not demonstrate that the public was provided with copies of the special motion included including the grounds in English, Kiswahili, prayer, and other communication channels and technology accessible to persons with disability, such as the Kenya Sign Language. In Turkana, as an example, as well as other marginalized regions where the report shows zero response via hand delivery and email, the report does not demonstrate whether it provided any mobile registration units or outreach as required by the PPI case to ensure nomadic communities were also involved. The notice, as I think has been mentioned again, presents a one-sided script. It presents the public with the grounds for impeachment without the first petitioner's response. This was not a search for truth. It was an exercise in prejudice. By suppressing the petitioner's side of the story, the state violated its rights to fair hearing and public's right to make an informed decision under Article 47 and 50 respectively. And this is found in our submissions, page 48 and paragraph 107. One submit that since the reasonableness of the notice is to be determined on case-by-case basis, the adequacy of notice in the present impeachment process can be tested against the scale of electoral mandate it seeks to overturn. This is found also in the submissions, page 47 and paragraph 104. In 2022 Kenyan general election, the presidential mandate was exercised by approximately 14.3 million voters out of about 22.1 million registered voters nationwide, reflecting a wide democratic participation. Out of those who cast valid votes, roughly 7.1 million supported the ticket of William Ruto and Rigathi Gachagua, thereby conferring upon them the constitutional mandate to govern. This mandate was granted by voters decentralized across the 290 constituencies and dispersed across at least 24 counties in accordance with the constitutional requirements. That is also in our submission, page 4 and paragraph 2. Therefore, by contrast, a constitutionality compliant impeachment process ought to demonstrate that the public participation notices reached a substantial and representative proportion of that electorate. In the present case, the notice issued reached only a negligible fraction of the electorate, attributed to short times, limited publication channels, and accessibility to forums, which processes clearly falls short of the constitutional standards. And of course, my learned friend Tom Macharia has mentioned that this is evidenced by the alleged 200,000 plus viewers in the National Assembly report, which constitutes about 0.14% of the vote that mandated their win. Your Honor, statistically, of course, it sums up to a 0%. If it was a medical test, it will show negative results. There were only 11 memoranda that were presented to Parliament. Your Honor, and again, this I think has been said, I won't repeat it. This begs the question whether the National Assembly is suggesting that the sovereign will of 22.1 million registered voters in the nation is carried in the hands of the 200 plus individuals who allegedly participated in the exercise. Your Honor, as you retire, you will find that the National Assembly's failure to issue reasonable notices contributed to the dismal performances in the public participation exercise, which cannot be taken to proportionately hold the views of the majority who voted the President and Deputy President into office. I also dare to say that the mode of the instruments that were used to collect information, the template instruments used in the public participation exercise lacked clarity, thus ambiguous, contrary to the Supreme Court guidelines. The viewers template instruments to collect data from the public participation exercise failed verification and identifiability test. And of course, we've mentioned that initially, which I think is a point note, they were the first templates that did not have provision for identification. Then later, they were replaced. But we don't know the forms that were already in the public. What happened with them? Did they collect data? Is that data part of what was collected and reviewed? That information we don't know. Parliament equally did not state clearly how they were verifying the information they got from the public. Finally, let me just finish now. I wish, just to draw to your attention, this was your ruling here in this court, in the same case of Gachagua. Gachagua and 40 others, versus the Speaker of the National Assembly, and 15 others. 224 KEH 13473. This is what you stated. The impeachment case exemplifies the dilemma faced by the judiciary when handling cases that straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue, one that has significant implication for the doctrine of separation of power. Your Honors, the eyes of the nation are indeed upon this court. We echo your sentiments in paragraph 101, which reminds us that the people of Kenya fought for a transition away from marginalized judiciary. They envisioned a new order where government excesses are checked and where no harm of government operated beyond scrutiny. If the standard of public participation is allowed to fall as low as it did in this case, characterized by unverified templates, digital exclusion, and binary trap, then the Constitution promise of the will of the people becomes a dead letter. Thank you, Your Honors, for the opportunity to address you.
Thank you.
Good afternoon, my lords and my lady. I rise to highlight issue for determination E.
Your name, please.
My name is Echesa Willis. My lords and my lady, I do rise to address and highlight submissions with regard to the issue for determination number E, that is at page 11 of the issues for determination, as have been crystallized by the first petitioner. My lords and my lady, the substance of issue number E is to be found at page 51 of the first petitioner's submissions. And my lords, taking cue from the presiding judge's direction, I will not repeat what my learned colleague, Mr. Tom Macharia, has addressed the court with respect to Article 47 of the Constitution, as well as Article 50, sub-Article 1, with regard to the right to fair hearing as well as fair administrative action. My lord, I will, for purposes of guiding the court in appreciation of this issue for determination, I will draw the court's attention to the further amended petition, specifically averments contained at paragraph 97, as well as paragraph 106. My lord, that is the foundational essence of the issue for determination that I shall be highlighting. My lord, further to that, I do redirect the court's attention to the affidavit in support of the petition sworn by His Excellency Rigathi Gachagua. My lord, this is sworn on the 18th of October 2024. And my lords and my ladies, specific to the issue that I'm highlighting on, issue number E, my lords, I do direct the court's attention to the deposition made at paragraph 8H, that is at, it's not paginated. The next factual preposition, my lord, is the deposition made at paragraph 22. And lastly, I shall make reference to the supplementary affidavit of His Excellency Gachagua, sworn on the 27th of October 2024, specifically at paragraph 6. My lords and my lady, against the backdrop of what my learned colleagues that have made submissions ahead on the provisions of Article 47 as well as Article 50 sub-Article 1 that embody the requirement of fairness in decision-making before decision-making bodies, as has been submitted, my lord, the role of the Senate in this particular proceeding leading to the impugned impeachment, it has been submitted ably by my learned colleague, Mr. Macharia, that this was a quasi-judicial process. My lord, submissions have been made with reference to, and in this particular, at this particular juncture, I do refer to the exhibit RG1, that is, my lords, the exhibit to the supporting affidavit that annexes exhibit number 1 that starts at page 566 through to 566 through to 583, my learned colleagues did indicate that there were pre-coalition agreements, and my lord, I would urge this court to take note of the specific provisions in these coalition agreements, specifically at page 588, which is specific with regard to the reservation of the position of the Speaker of the Senate. My lord, I refer to, this is the agreement between the Kenya Kwanza Alliance Coalition and the Pamoja Africa Alliance Party. Next, my lord, is page 567 that exhibits the coalition agreement between the United Democratic Alliance and the Amani National Congress Party and Ford Kenya Party. I will redirect the court's attentions to page 578. This is at Article 21, subparagraph L and N. My lords and my lady, what those annexures, the purpose of those annexures is to amplify the fact that the speakers of both the National Assembly as well as the Senate were direct beneficiaries to the pre-coalition agreements that were in place, and that which had been submitted by the first petitioner first before the National Assembly on the 8th of October 2024 in response and in his defense with respect to ground 1 that raised the charge on the so-called shareholding issue. My lords and my lady, the point to underscore in regard to those coalition agreements is that as early as the 8th of October 2024, when the first petitioner tendered his defense to the grounds that were purportedly moved by the National Assembly, it was clear that part of the evidence that the first petitioner was to present implicated or showed the involvement and the interest of the Speaker of the National Assembly. However, my lords and my lady, the Speaker of the National Assembly did not deem it fit to recuse himself, noting that the issue of his interest would play out in the defense of His Excellency Rigathi Gachagua. Further to this, when the motion was, or reasonably believed that it was seen by the then Speaker of the National Assembly, the Speaker of the Senate, that the coalition agreement that begot him his speakership was also in question, as it had been brought up by the first petitioner in his defense of ground 1 that had been then passed by the National Assembly. In summing up, my lords and my lady, impartiality is essential for decision making, and as my learned colleagues have indicated, the process demonstrated what my senior counsel, Mr. Ongoya, has referred to as malicious compliance, breakneck speed with regard to the moving of the motion, as well as the directions, as well as interpretation that was given to various provisions of the Constitution by both the Speaker of the National Assembly and that of the Senate. In summing up, my Lord, the petitioner has, in his bundle of digest and bundle of authorities, made reference to the decision of Njiru and 11 others versus Kenya Kwanza Coalition and 18 others, which my learned colleague, Mr. Macharia, made reference to. I do urge your lordships and your ladyship, when this court retires to deliberate on the ruling, on the judgment, to be guided by the 3 judges in holding number 20 and 21 of that decision. I do submit that those 2 holdings are on all fours on the submission in relation to Article E before this court. So the issue for determination at E before the court. And in closing, my Lord, with reference to the issue for determination whether or not the speakers of both the National Assembly and that of the Senate were neutral, I do invite this court to do what the court recommended in the decision of Philip K. Tunoi and another versus the Judicial Service Commission and another, it's a 2016 decision, where the court held that in determining the existence or otherwise of bias, the test to be applied is that of a fair-minded and informed observer who will adopt a balanced approach and will neither be complacent nor be unduly sensitive or suspicious in determining whether or not there is a real possibility of bias. I do invite this court to apply that test. And my lords and your ladyship, based on what has been presented by the petitioner, we do submit and urge the court to find issue number E in the affirmative. I'm much obliged.
Thank you.
May it please your lordships and your ladyship, my name is Faith Waigwa for the first petitioner. My lord,